what I was saying in my introduction is that nothing about my career in the law has been conventional. And so what I thought I'd do is to give you a bit of personal and professional background, and then talk about how that led to a career in the judiciary. I, just on a personal note, I was born in London to Nigerian parents, and you know, grew up in London, you know, went to school in London, etc. And when I was 13, the whole family relocated to Nigeria. And although I'd been brought up in a traditional Nigerian family, I was sort of very English in my outlook. So being taken away from sort of everything that I was used to was quite traumatic, and it took me a long time to adjust, but I did. So most of my secondary school education was in Nigeria, and it was probably shortly before I took my O-levels that I started to think about career choices. Believe it or not, law was not my first choice. I started off wanting to do sciences. In fact, biochemistry was my first choice. Don't ask me why. I have no recollection as to why I chose that. I'm not sure that I even knew.
Oh, we've lost you again.
Oh, yeah. But because we're seeing other people moving, it means it's not our connection now. Yes.
Where's she speaking from?
From home.
I'm not sure where she is, but I don't know.
Oh.
I don't know.
What do you think? How do you think you have?
Sorry, Nikki. Well, the connection's just gone, hasn't it?
Yeah. Unless Nikki's got a few devices linked to the broadband at home, I don't know. Is that because sometimes
I don't know. Look, so the evening is not completely lost. Thank you for coming. Perhaps I will fill in a bit, because I know Nikki as an employment judge from my time as an employment tribunal lay member, so sitting on the sidelines to Nikki and other judges' judgment. Oh, she's back.
And that was my casual introduction to the law. So, but having casually decided to become a lawyer, I did stick with it. And after completing my A-levels in Nigeria, I fully intended to continue you know, in Nigeria by going to university and doing a law degree. What you need to know about Nigeria is that law is a very popular and oversubscribed degree. And even in the 80s, when I was considering it, there was an oversupply of lawyers. So what happened was, when you applied to university, you'd have to give your first and second preference of course that you wanted to study. And if you were lucky, you'd get your first choice. But because law was so oversubscribed, people were often taken for their second choice, with the possibility of then doing their first choice as a second degree, which meant that your time in university was that much longer. And that's exactly what happened to me. I got a place at the University of Lagos to study English, which was my second choice, whereas law was my first. So I had to make a decision, really. Do I want to spend 4 years studying a degree that I didn't really want to do before spending another 3 or 4 years doing the degree that I did want to do? So I decided not. So I decided at that point that I'd come back to England and continue my university education here. So January 1982, I think I was about 18, I came back. And I remember it being a really cold winter and lots of snow. But I was delighted to see snow because I hadn't seen it for many years. So because I'd missed probably the first term of what should have been my university year, I decided that I would apply for university in the September, and in the meantime do an extra A-level. So I did an extra A-level in law. So this is the point at which my route to the law became unconventional, and a departure from what one would expect. Now, I had expected, perhaps naively, that as a British citizen, which I still was, I would be able to go to university for free. Apparently not. Because I had been out of the country and not resident anywhere within the UK for a continuous period of 3 years, I was treated as a foreign student, and which meant I had to pay foreign students' fees in order to do my degree. And I wasn't in a position to do that. And so I had to make a decision, another decision. Do I wait 3 years before starting my degree, at which point I'll have been around resident for 3 years and be entitled to it for free? Or should I look at another path towards a degree? So I decided on the latter route. So what I did is I signed up for the University of London External LLB. And so what this did, it allowed you to do a London University degree, but study outside the university, either through an independent college or just independently, and for a fraction of what would have been a foreign student's fees. So that's the route I took. I did it through Holborn Law Tutors, which meant that I attended classes every Saturday. And then during the week, I worked. I had a job at a building society. I was based in Brighton at the time, and I had a job as a mortgage administrator, working Monday to Friday, going to college on a Saturday in London, using my holidays to revise and take my exams. And that's how I got through my degree, as well as having two or three other jobs on the go at the time. Now, I eventually got my law degree. It took me 4 years rather than 3. I then had to decide which branch of the profession I should go down. Should I be a solicitor or a barrister? I actually wanted to be a barrister, but by this time, I'd bought a flat with my younger sister, who had also returned to England, and so had part of a mortgage to pay. So I couldn't have afforded to work for nothing as a pupil barrister. So I decided to go down the solicitor route, which meant that I had to do the Law Society finals. So I was on a waiting list for a place at the College of Law in Guildford to do my finals. So in the meantime, I continued to work at the Building Society. But now, because I'd now passed my law degree, they transferred me to the legal department. So I was dealing with mortgage repossession cases and the conveyancing associated with that, and working with other lawyers, which was great for me. A place then came up at the College of Law the following year for my solicitor's finals. There was then the issue of how I was going to pay for it. It was a full-time course for 1 year, which meant that I had to give up my job at the Building Society. I also had to move into digs locally, as it was too expensive for me to commute daily from Brighton. Now, of course, by this time, I had been resident in the UK for more than 3 years, but there was no automatic right to a grant for the solicitor's finals. though there was a discretionary grant available through my local authority. So I applied, and my application was refused. And the reason that my application was refused was because I was over 25. Now, that was many years before we had age discrimination legislation, but that didn't stop me from, you know, complaining and alleging that it was discriminatory. I appealed, and I got my local Liberal councillor involved. But in the meantime, I had to take up the place, or it would have been lost. So I took up my place, and I decided that if my appeal was unsuccessful, I'd take out a loan. As it happens, my appeal was successful, so I did get a grant, but covering just the tuition. So I still had to pay for my accommodation. So as with my law degree, I studied and I worked, except that this time I was studying full time and working part time. So I had a couple of cleaning jobs. That's what I had, which I did in the evening. I did a house cleaning job 1 day a week, and then at the weekends I worked in the kitchens at a beef eater restaurant. So I was very busy. But somehow I got through the year, and I successfully completed my solicitor's finals. Then came the next challenge, getting articles. Now, the law was at that time, and I'd say remains today, a very conservative profession, and law firms in those days didn't really embrace the unconventional. So that presented difficulties for me when applying for articles. I mean, my CV would have been their worst nightmare. Most of my fellow students at Guildford had sorted out their articles straight from university. However, at the end of my course, I still didn't have articles, and I spent several months making hundreds of applications without success. So in the meantime, I went back to work for the Building Society temporarily. And then out of the blue, the head of the legal department asked me whether I wanted to do my articles there. Now, this wasn't anything that they'd ever done before, and so they had to check with the Law Society that they were able to offer me a sufficient range of legal work, and the Law Society said yes. So that's how I did my articles at the Building Society. It's now a bank. But actually, they were able to offer me a wide range of legal work to do. And the bonus was that the Law Society allowed me to count some of the work that I had done in the legal department between finishing my solicitor's finals and starting my articles as counting towards my articles. And that meant that I was able to qualify as a solicitor within 18 months instead of 2 years. So there it was. On the 1st of May 1992, I became a qualified solicitor. So that's my sort of convoluted summary of how I became a solicitor. What I want to talk about now is how I went from being a qualified solicitor to becoming a judge. So, all right, so having qualified as a solicitor, the next stage really was to decide what area of law I wanted to specialise in. Now, I knew that I didn't want to do crime or family. That much was clear to me. The Building Society kept me on as a solicitor once I qualified, and I gained some good experience from them in the commercial world of banking and property. But I wasn't sure that that's what I wanted to do long term. Employment law wasn't even on my radar at that time. And in those days, it had a very low profile and was not considered an attractive career prospect. That probably explains why lots of women went into it, as it was one of the few areas where they were not in competition with men. Anyway, the turning point for me was in 1993. The building society was having some major industrial relations issues, but had nobody within the legal department that knew anything about employment law. So they hired an employment law specialist, and I started to work closely with her. And I worked with her on the first tribunal claim that the building society had. And that claim, it went all the way to tribunal, and I attended the hearing, which I think was 2 or 3 days. And I watched my colleague in action. And I think from that point I was hooked. I thought this is a really interesting area of law. So a couple of years later, my colleague left to go into private practice, and she wasn't replaced. So that left me as the only person in the department with some employment law knowledge. I wouldn't say expertise, because I certainly couldn't claim to have that. But somehow I became the go-to person whenever somebody had an employment related query or issue. So I did a lot of learning on the job, and as I had nobody to turn for advice, my mentor having left, I had to self-learn. And so gradually, as time went on, I became more familiar with the area of law and built up an expertise. And so after a couple of years, I then left the bank, which it was by then. But my real break came in January 1995, because that is when I joined the Engineering Employers Federation as an employment law advisor. And it was there that I built up a real expertise, as my role was to advise its members on employment related matters and disputes and represent them in tribunal. And I did that for just under 15 years. Now, being a judge was never really part of my career plan. In my mind, a judicial career is what barristers aspire to, not solicitors. So, as with much of my career, my route into the judiciary was unplanned. And this is how it happened, actually. I happened to be flicking through the Law Society Gazette one lunchtime, and then an advert caught my eye. And it was an ad for fee-paid employment tribunal chairman, as employment judges were then called. My first thought was, I didn't know the judiciary advertised for judges, because I thought judges were appointed by a tap on the shoulder, which is what I've been told. And actually, it wasn't entirely inaccurate. Though it seems at that time things were just starting to change. So I saw this ad and I became intrigued, and I thought, well, let's just have a look and see what they're looking for. So I looked at the criteria for the role. 7 years post-qualification experience. I had that. 35 years of age, or at least 35 years of age. This was obviously pre-age discrimination. But again, another tick. Experience in employment law, another tick. And so as I read this advert, I thought, blimey, I could actually apply for this role. And so I thought, well, why not? And so I did. Now, the application process was horrendous. it was my first experience of a competency-based selection process. Now, I was of the old school where you applied for a job by sending off a CV and you went to an interview and talked about your experience. This was completely different. I had to give examples of how I met various competencies, and I found the process very, very stressful. So after sending off the application form, attending interview, going through the process, I forgot about it and I thought that was horrendous. I'll just put that down to experience. And I had no expectations whatsoever of being appointed. So it was a real shock when about 6 months later, I received a letter offering me the position of a fee-paid chairman of the employment tribunal. So fee-paid judges, as they are now, have to work at least 6 months. Well, they have to do at least 30 days of sit-ins a year. So it's something really that you work around your existing practice or job. So I did this while continuing with my job at EEF. So I sat initially in Leeds, albeit very briefly. Then I sat in Cardiff for a number of years, and then finally sitting in Southampton. It got to the point where juggling this fee-paid appointment and doing my full-time job became difficult for me to maintain, especially as I was also at the time, caring for a new baby. So when the opportunity came to apply for a permanent judicial position, I jumped at it. This time round, having sat as a fee-paid judge for 6 years and had experience of the recruitment process, I was a lot more confident about the process. And I think I'd finally reached a point in my career where I knew exactly what I wanted to do, and that was to give up practice and become a salaried employment judge. And so in November 2009, I eventually became an employment judge, permanent employment judge, based in the London South Tribunal in Croydon, and I have been there ever since. Now, being an employment judge is, I'd say, it's an important role, and it's one that I find extremely rewarding. You know, you're dealing with real people and their lives. You're learning so much about different professions and workplaces, and also about the way that people interact with each other in the working environment. I find it fascinating. The profile and popularity of employment law has risen exponentially in the last 20 years, particularly because of the European dimension. So we're now at a point where barristers and senior solicitors are leaving practice in their droves to become employment judges. Now, if anybody had said to me at the end of my O-levels that I would end up becoming a judge, I think I would have laughed them out of the room. Because my perception of a judge at the time, and for some time afterwards, was of a white male, Oxbridge educated. Now, that tended to be the norm, and probably still is for the senior judiciary. However, at the more junior end, things are changing, and that change is probably best reflected in the employment tribunal, which I think is probably the most diverse part of the judiciary, and has been for quite some time. And that point struck me on a case that I sat on last year. Because what I remember is that the panel comprised of myself, a black woman of African descent. One of the panel members was an Asian woman, and the other panel member was a Caribbean male. Not only that, the barrister for the claimant was a black male. And I remember looking around the room and thinking how fantastic that was, and how other parts of the judiciary could learn from us. So that really is a potted history of how I became an employment judge. So I'm hoping that you're all still there, and that I haven't just been speaking to myself. Can you let me know that you're still there, Val?
Val isn't, I don't think, Nikki, but there are a few of us that have been listening. And I just want to say how
Thank you. Yes, thank you.
Great. I mean, I'm sorry that I can't see you and that we couldn't get the connection right, but I think Val said that there might be some questions. I don't know whether you got some questions from people in advance, or whether anybody has any particular questions for me.
So I suspect you've covered over some of the worst excesses of white middle-aged men along your journey. It can't have been as easy as you made out.
Sorry, say that again.
I think you might have glossed over some of the worst excesses of white middle-aged men you'll have encountered on your way up the journey.
Well, yes. What can I say? I think over the. I mean, I'm just trying to think. It's probably over. I've been involved in the employment tribunal for over 20 years, and what I do know is that I suppose I'm just trying to put this delicately. That certainly there were some types of employment judges that you don't see now. The training that we get now is much better than it was many years ago. There's a lot of training on equal treatment, on diversity, on how to interact with the parties, and I think that makes for a much better judiciary, because what you've got to remember is that a lot of the punters that come before us are unrepresented, and many of them are vulnerable. And so we have to adapt our approach to them to ensure that they have proper access to justice, because I think it is very. I mean, when I represented in tribunal, my witnesses, my clients would say how intimidated they felt being in a tribunal and being in the witness box. So you can just imagine how somebody who is representing themselves and is faced across the table by an army of lawyers and perhaps their ex-employer and colleagues that they used to work with and they've fallen out with. You can just imagine how difficult it must be for them. And so we do have to take that into account and assist as much as we can without actually going into the arena. But I found many years ago when I appeared in tribunal that perhaps the old school of judges were not quite on board with that, if I can put it that way.
So what's next then? What's next for the judiciary? So it seems to have changed a lot during the course of your career. Where's it going next?
Well, are you talking about the judiciary as a whole, or
employment law?
Employment law.
Yeah.
Well, that really depends upon what knock-on effect there is going to be with us leaving Europe with Brexit, because I think when Theresa May was still Prime Minister, I think at that time the government's position is that there wouldn't be any watering down of employment rights. I'm not sure whether that same commitment, whether we have that same commitment from the current government. I may be wrong, but of course now you've got the added dimension of COVID, and what we do know is that it's going to result in a lot of job losses, and the knock-on effect for us is that that's going to result in lots and lots of tribunal claims, probably lots of redundancy claims, of course, lots of claims possibly by unions about consultation, possibly claims of discrimination connected with furloughing and maternity, and whether people were should have been furloughed, whether they shouldn't have been furloughed. So I think it's going to be a very, very busy period. So there's also the prospect, isn't there, of fees coming back at some point. Although I suspect that's not, I suspect that's not the main priority of the government at the moment. So we'll have to see. And of course, we've got this massive backlog of cases because we've had to adjourn lots of cases because of the social distancing. I suppose one of the changes that has occurred because of COVID is the increased use of video hearings. And so I suspect that will continue to a degree, but it won't be a replacement for face-to-face hearings. But I think where it's practical to use video hearings, not Zoom, I hasten to add. I think that there's a custom-made video conferencing facility for the tribunals. I suspect that we will be using it increasingly, and in fact having hybrid hearings as well, where some parties will be in the building and some will connect via video conference. So that's what I see is likely to be on the horizon, certainly for not just for the employment tribunal, but probably across the judiciary.
Yeah, I did hear a horrific story earlier this week about British Airways, for instance. I'm going to raise it. I don't know whether they're going to end up with a class action for it, but British Airways persuaded a lot of its pregnant employees that they'd get more money if they were furloughed as opposed to on maternity leave. And then at the minute, so they got all these pregnant women to go on furlough rather than be on maternity. And then they suddenly realised that it was easier to make them redundant when they were on furlough when they couldn't make them redundant on maternity. So they've now made a whole load of these employees redundant. Some of them, at least one I know of, only had a baby 2 weeks ago and has now been made redundant, and is getting no money when she thought, because she was on furlough, she would be safe and getting more money. So I can't help thinking there'll be more abuses like that just rattling around the system.
Well, as I say, these are going to be interesting times, and we are, as employment judges, going to have to grapple with all of these sort of new types of claims arising from this process. And the other thing is that lots of companies will go to the wall because of the COVID situation. So a lot of people may find that they haven't really got, well, that even if they do sue their employers, that there's no money at the end of it because they've gone bust. And that's probably going to be the case for a lot of small to medium firms. So you know, it's I think we've got some pretty hard times ahead, across all sectors really, as you know, you probably know.
Could I ask a question? And I'll declare an interest straight away as a white middle-aged judge, but one like yourself, Nikki, has perhaps a degree of diversity because I'm also a solicitor, state school, non-Oxbridge, etc. Yeah. But I'm interested in diversity in the judiciary. Obviously, it's a hot topic.
Yes.
And like you, I had the experience of going through the JAC selection process, and I thought it was rigorous, and I thought it was rigorous, but it also was fair. And,
yeah.
And actually, I think that's what the public want. They want their judges to be selected through a fair but rigorous process, because obviously, we're making decisions that have big effect on people's lives, and people are entitled to think that the people who take them are qualified to do it properly.
Yeah.
But there is a problem, is there not? Not in the tribunals judiciary. Like yourself, I'm a tribunal judge. I sit in the upper tribunal tax and chancery chamber.
Yeah.
The tribunals generally, not just employment tribunals, are diverse to the point where it does actually reflect the population balance in many respects.
Yes.
Or pretty close to it. Yeah. Where it hasn't hit is in the higher courts, the High Court and higher.
Yes.
Where there is a big issue, particularly amongst Afro-Caribbean or Black community as generally. Yeah. Now, do you think the selection process needs to be changed to change that, or what is it that means that it's easy to get diversity in the tribunals, but it's not so easy in the courts? Because I don't know the answer to that. I don't know whether you've got any insight into why that is the case.
Well, I don't know the answer to that either, and I actually do sit on the JAC interviews, but for the sort of the lower tier. But I do see the adverts for some of the higher positions, you know, senior circuit judge, high court, deputy high court judge, etc. And I mean, there's nothing specifically in the adverts that is unfair. But what I found interesting, and it must have been, maybe it was last year, there was a whole appointment of deputy high court judges, and I looked at them all, and of them there was only one, I think, or maybe two, that didn't go to Oxbridge. And I don't know. It's very difficult, because, you know, the process shouldn't it shouldn't end up having, you know, a number of judges all of the same type, because this is what you know, open competition was meant to avoid. It was,
yeah, and it shouldn't happen, because on the application you don't declare where you went to school, you don't declare where you went to university.
No, I know.
So it's not as if the people who are interviewing you know what your background is, and yet it still comes out the way you've described.
Well, maybe it comes out like that because I suppose the pool of people who, I suppose, feel that they are suitable for, you know, high court appointment. I mean, you're generally looking at, aren't you, people who are maybe senior partners, top QCs, and so those people will generally be people who have gone through the Oxbridge route. And so I suppose it's self-perpetuating, isn't it?
Well, maybe there's a lack of ambition. Maybe that's the answer, is that people from less conventional backgrounds need much more encouragement to apply. And I think you may be right, in the same way as a lot from the BAME community don't necessarily apply to Oxbridge when they should, because they think that's not the sort of place people like me go to. Maybe the same is true. Maybe the same is true of people, budding judges who think, oh well, I'll be comfortable in the tribunals, but no, the High Court's beyond the likes of me, and I shouldn't even bother to go there.
Yeah, I think there's certainly an element of that. I'm not sure to what degree, but I would suspect to a large degree that would be the case. But also, I suppose, that it may well be that they haven't been exposed to the types of opportunities that would, allow them to go forward for that sort of position. Because remember, you still got to set out in your application form the type of experience or give examples of the type of things that you have done which match the competencies which mean that you are appointable, and it may well be that people haven't had that sort of exposure to those sorts of opportunities. Because what lots of people say to me about applying for even entry level judicial position is that, well, I've been in the same job for the last so many years, I haven't really had an opportunity to demonstrate that I can meet these competencies because my job's pretty mundane, nothing changes, and so I think sometimes they feel that the application form itself is a barrier because they don't know how to or they don't recognise the elements of the competencies in the job that they do, and that's the problem.
Well, there's a very good training course that I went on that the Law Society ran about how to apply to be a judge.
Yeah,
and it helped me immensely.
Yeah,
and I can't but think that people that you described wouldn't be helped if there was more encouragement to do so. Do you? And I'll finish here because I'm monopolising the conversation. But do you think is there any suggestion that we should have quotas? Do you think there should be some? Do we need radical action to address it, or do we just wait for things to take their course naturally, even though it may take a generation to do it?
Well, I think quotas. I'm not sure there is a plan for quotas.
There isn't at the moment.
But no, there isn't at the moment, and I think I don't know how quotas would necessarily be received. I mean, what they have is what's that noise? Sounds like a seagull.
It was a seagull. It was a seagull. Sorry.
Okay.
One of our friends.
Yeah. Well, what there is an equal merit provision in the Equality Act. So, which the JAC will apply to positions, but that applies where you have, for example, two candidates of equal merit, and with nothing separating them. And in those circumstances, you can look to see whether there's a need, there's a shortage of a particular group, and then you can decide on an equal merit basis to offer the job to the underrepresented group. But I always think nothing's ever equal. There are always differences between candidates. So I'm not sure how widely that is used.
I doubt if it's being used very often at all, actually. I suspect it's not been necessary.
No, indeed. I suspect so too. I mean, it's there to be used, but I'm not sure whether it would make a fundamental difference to the numbers coming through the profession. And I think what we've seen with diversity is that whereas I think it's the profession's a lot more diverse in terms of gender, and there are now more women becoming judges. The same diversity hasn't happened as far as sort of ethnic minorities are concerned, and that's and that's very that's been very slow progress there. I mean, I think once you get beyond circuit level, I think you can count on one hand the number of ethnic minorities in the High Court, Court of Appeal. I'm not sure. I think there might be a couple in the Court of Appeal.
There are 2 in the Court of Appeal, none in the Supreme Court, and there's, as you say, probably a handful in the High Court.
Yeah. So yeah, I don't know. I don't know what the answer to that is. I mean, there are, the JAC do seem to run programs to try and encourage people, but I think what you find is that there are quite a lot of ethnic minority at entry level. But what doesn't happen? One of the things that judiciary doesn't have is an internal promotion sort of system.
No, you have to apply for every job on merit, and
exactly. So and that's, I think that's, if they could do something like that, then that may well be a way of because what tends to happen is that people tend to be stuck in the level stuck at entry level.
Yeah.
And they then don't go beyond that. So I mean, we've seen some movement, just a bit of movement now, and you see that some employment judges becoming recorders and then becoming circuit judges, and you're even getting some employment judges who become circuit judges straight away without sitting as a recorder. But they're very few and far between, and they're not ethnic minority. I don't know any ethnic minorities who that's occurred to. How has happened to. So that, again, that in itself isn't the answer. But I certainly think making opportunities available internally rather than having to advertise everything externally might be a way forward.
Yeah.
Could I come in here? Nikki, I think we've lost the control centre at the National Liberal Club. And we're probably now eating into time that you haven't got, as you're off somewhere tomorrow, I understand.
No, fine. Yeah.
But I just wondered if I could ask you, you mentioned going along with your unconventional law career and the fantastic success that you've had, and the fact that you really love it, obviously. How did you cope with having a family, and how did that go? If you'd like to share that with us.
Well, I mean, that was hard. I mean, I've just got the one son. But even
and are you going to encourage him to be a lawyer?
Even if I could, I'm sure he wouldn't be. At the moment, we're at the stage of him wanting to be a YouTube influencer, whatever that is. But that's where we are. So.
And you found it easy to combine having him growing up alongside your unconventional law career?
Well, when I had him, I was still fee paid, a fee paid judge, and working full time in practice. So that was hard because what I found is that even when I sat on my sitting days as a judge, I would take a day's leave or a number of days leave off my main job, because of course I'd be paid by the judiciary. But even though I'd taken unpaid leave from my day job, the day job didn't stop. And of course, with email, clients can contact you whether you're there or not. So I'd get loads and loads of emails, loads of phone messages. So I'd spend a day sitting as a fee paid judge, and then I'd come home and then have to deal with all the email traffic and messages from my day job. So it was very difficult. And of course, decision writing had to be done in my own time as well. I mean, although you could, in theory, claim a fee for writing up judgments, I was, loath to do that very often, because I always used to think, well, should I be taking this long writing up a judgment? And isn't the reason I'm taking so long to write it up because I'm trying to look after this young baby as well? So I didn't really feel that I should. claim a fee for writing up the judgments. But I did find it. I found it hard because my son was quite young then as well. I think he was sort of 2 or 3, and he wasn't sleeping through the night. So whereas when I was younger, young, free and single, I was able to juggle 2 or 3 jobs quite easily. As I got older and had a family, it wasn't quite as easy as it had previously been. So and that was really one of the reasons why I decided that I was going to apply for a permanent judicial post. And of course, the thing that is great, the most fantastic thing about having a permanent judicial post is that you don't have clients. And it's just, so it's a different, it's it is stressful, but it's a different kind of stress. It's not the sort of stress that comes with clients contacting you all the time and thinking that you are contactable and at their beck and call any time of the day, at weekends, and even when you're on holiday on the beach in Greece, which is what happened to me.
The other thing I just wanted to comment on was the way in which the building society in Brighton that you sort of started working for and did more and more work, and one thing led to another, that became quite a ladder of opportunity. And it sort of points to the fact that the non-traditional way of developing a career, there's much more scope for something like that going forward. I think that's a very interesting part of how you got from A to B, and well,
yes,
A to Z probably.
Well, yes, it is, and actually, I've my sort of colleagues that I have now, quite a number of them have come to the judicial careers from unconventional routes. I've got a colleague friend who came from the Navy, another one that came from the Army. I've got a colleague who did a degree in music, another one that did a degree in geography. So quite a few of them. And in fact, I've got another colleague who started off as a teacher. In fact, there are quite a few of my judicial colleagues who had teaching careers first before coming to the law. So I'm not unique in not having come through the traditional route. But what I do think is that it gives you a much broader sense of what life is about and what people are about. I mean, there are lots of judges, certainly the old school judges, who have gone from the bar to the judiciary. They've never worked in a workplace. Barristers are self-employed, and so sometimes there was a feeling that they were not really in touch with the way life was on the ground. But I think nowadays a lot of the judges are a lot more savvy, know a lot more about workplaces and how they run and the dynamics that you have within a workplace. For those who know about the employment tribunal, we always used to sit with lay members, especially on the unfair dismissal types of claims. And the idea behind that was that they would bring their industrial experience of the workplace to bear, because the judge would be a solicitor or barrister. They'd know nothing about how ordinary people worked, and that has now changed, because I mean, unfortunately, we don't sit with members on unfair dismissal cases, but the judges now are a lot more savvy about how various industries work and the general dynamics that you have within a normal workplace. So they're not as out of touch as they were perceived to be many years ago.
Well, thank you for that. As we seem to have lost most of our colleagues, I just wondered if people I can see on my screen, Kate or Roshan or Ella, whether you want to do a sort of final question before we wrap up and thank Nikki for persevering with this, which has been absolutely amazing.
No, just wanted to thank, yeah, I just wanted to say thank you for a very, very interesting story for life, really.
Oh, thank you.
I agree.
I mean, and it shows so much bravery and perseverance and, you know,
well,
all the way through. So it's really, really quite inspiring.
Oh, thank you very much.
So interesting. Completely hooked. So I'm afraid I have to dive out now anyway, but I really, really enjoyed this evening. Thank you.
Oh, thank you very much. Thank you.
Thank you, Nikki.
You know,
thank you.
We've all enjoyed it enormously, Nikki, and we look forward to seeing you sometime at the National Liberal Club.
Yes, yes, again, sorry that I couldn't be there in person, but yes, I would certainly, yes, I will come again.
Excellent, excellent. Well, thank you for persevering, because it was really well worth it, and thank you so much.